Okay, so good evening everyone again. So of course, tapusin natin yung ating evidence. Then of course, kapag matapos natin, makaproceed tayo sa book 2. Kasi of course, ang explain natin sa book 2 class, yung mga crimes lang na mostly nag-appear or tinatanong sa board exam. Hindi masyadong maganda yung lighting natin. So okay lang yan. Ang importante, yung ating presentation. Okay? So again, as a review, i-review muna natin na before tayo magpumunta sa ibang area. Okay, so under the rules of evidence, so we have the rule 128 to rule 134. Of course, meron tayong 7 rules of evidence. So that is, again, ang ating acronym na ginagamit dyan is Great Women Ruled are Born to Pakwin Peak or yung GWRBPWP. Again, we have the rule 128, yung general provisions na tinatawag natin. Rule 129 naman, what need not be proved. Rule 130, we have the rules of admissibility of evidence. Rule 131, burden of proof and presumption. Rule 132, perpetuation of witness. Rule 133, the weight and sufficiency of evidence. And of course, the Rule 134, the perpetuation of testimonies. Actually, some of the content o yung pinaka-basic na dapat ninyong malaman, actually kagabi natapos na natin doon, yung kinds of evidence, yung rules of admissibility of evidence, and so on. But of course, we will proceed to more yung detailed pa. Okay? So, dito tayo. Okay? Please try to answer this one, class. Okay, so any person who can perceive and perceiving and can make known their perception to others. Letter A, subject. Letter B, witness. Letter C, accused. And letter D, suspect. Again, any person who can perceive and perceiving and can make known their perception to others. Sino yan? Sino yung tinutukoy under the rules of evidence? Sige nga. Please answer. Okay, so lahat mag-participate ha. Paki-screenshot nga class yung ating presentation, then pakipasa sa ating GC para makita rin ng mga kabatch ninyo or kaklase ninyo. Baka hindi pa nila nakita. B. Okay. Sige. Na-screenshot nyo na ba, class? May nag-screenshot na pakipasa doon sa ating GC para makita ng iba. Again, any person who can perceive and perceiving can make known their perception to others. Of course, ang sagot natin dyan, that is witness. Okay, so that is the definition of witness, class. Again, ang witness, meron tayong tinatawag na two types of witness. Okay, so again, ang definition ng witness, yan mismo. Who can perceive and perceiving and can make known their perception to others may become a witness. Ibig sabihin, yung nakakaintindi or yung ginagamit niya yung kanyang senses so can perceive and perceiving and can make known their perception to others. Ibig sabihin, ma-interpret niya kung ano yung na-observe niya, ano yung nakita niya. Ang tawag natin dyan is witness. Okay? So anyone can become a witness. Kaya meron tayong child witness. Kapag tanong kung baka testify ba ang child, of course, yes. Okay, so yan yung tinatawag natin na witness. And of course, we have the two types of witness. Ano yung dalawang types ng witness natin? Ano yun? Paki-comment ka sa ating comment section. What are the two types of witness? What are the two types of witness? Paki-comment. Ordinary and expert witness. Okay, very good. So, tandaan ninyo, pag sinabi nating witness, we have the two types of witness. Of course, we have the ordinary witness and we have the expert witness. Okay. So, tandaan ninyo, ang ordinary witness, okay, i-type na lang natin dito. Ang ordinary witness will testify based on him. Okay, so ano yung tinatawag natin na him? Of course, yung letter H that stands for handwriting. Second, yung I is identity of the person. And yung M, that is the mental sanity. Okay, the mental sanity. Mental sanity. Again, tandaan niyo kapag ordinary witness, magta-testify ka, ang acronym na ginagamit natin dyan is based on him. Ibig sabihin, magta-testify ka ngayon based on the handwriting of the person, the identity of the person, and the mental sanity. Okay, so di ba alam niyo naman yung handwriting ng classmate niyo, ng schoolmate niyo. Kapag pinapatestify ka based on handwriting, okay, na magta-testify na siya yung nagmamayari nito, kasi naobserbahan mo, that is ordinary witness. Then kapag magta-testify ka based on the identity of the person or pagkakakilanlan niya, halimbawa, mataba ba siya, payat, singkit, and so on. So it talks about the identity of the person. So papasok yan ngayon sa tinatawag natin na ordinary witness. Then kapag magta-testify ka, class, based on the mental sanity or yung state of mind ng tao na yan, tatawagin ka ngayon as still ordinary witness. Again, kapag ordinary witness ka, magta-testify ka based on him, ibig sabihin, handwriting, identity, and the mental sanity of the person. Nakuha ba, class? Nakuha ba? Nasundan? Okay lang? Again,
Yes, sir.
okay, ang ordinary witness, tandaan nyo thank you. Ang acronym na ginagamit natin dyan is based on him. Okay, so ayan. While ang expert witness naman, class, meron tayong tinatawag na SETI. Okay, kapag expert, i-type ko na lang para makita nyo. Ang expert witness, of course, mag-testify siya based on CT. Ang CT naman, yung S that stands for skills. Yung E that stands for experience. Yung letter T, trainings. And of course, yung tinatawag natin na E is expertise or education. Okay. So again, ulitin natin, kung ang ordinary witness, magta-testify siya based on him, handwriting, identity of the person, and the mental sanity of the person. While an expert witness, magta-testify siya ngayon based on CT. Tandaan nyo lang yung acronym na CT, skills. Okay, yung skills niya, halimbawa, ako, yung skills ko is based on sa security, di ba? I am a certified security professional, di ba? So yun yung expert yung skills ko doon. Or ang skills ko is public speaking, di ba? I am a lecturer. So yun yung skills ko na hindi nila makukuha sa akin. So doon ka magaling or doon yung pinaka skills or kung saan ka pinaka nahasa. So that is the skills. Ang experience naman, of course, kung gaano ka katagal, okay? Gaano ka katagal sa business. Hindi naman ibig sabihin kung masyado ka na matagal, magaling ka. Hindi naman 'yon. So experience, so ang experience of course kahit ilang years ka pa lang diyan kung non-stop naman yung progress mo. So that is experience. Trainings naman of course halimbawa yung doctor, of course kahit natapos siya or nagpa-practice na yan, kailangan niya pa rin ng continuous training. So, papasok siya ng training and of course, yung education and expertise of that person. So, halimbawa, when you are a medical doctor or yung when you are a physician, then kinuha or hiningi yung tinatawag natin na expertise mo, experience, trainings, and education. So papasok ka ngayon sa expert witness. Kasi nga, ang expert witness, tinatawag natin or meron tayong tinatawag na CT. Skills, experience, trainings, and education. Okay. So I hope nakuha ninyo. So magbibigay ako ngayon ng scenario kasi ito mostly ang palaging tinatanong sa board exam. Kung naiintindihan ng student or ng reviewee ang difference between the witness or the expert witness and ordinary witness. Okay. So pag sinabi nating class, okay, pag sinabi nating okay, ito yung scenario kasi sa board exam. Okay, yung physician or yung doctor nung pauwi siya, okay, nung pauwi siya sa bahay nila, nakita niya na sinasaksak okay, ni Mr. A si Mr. B. Again, yung medical doctor or yung physician, yung habang or nung pauwi siya, okay, nakita niya or nadaanan niya na sinasaksak ni Mr. A si Mr. B. Okay. Then, relative to that, pinatawag siya ngayon ng korte. Okay, pinatawag siya ng korte. Okay, so ano siya na, anong kind ng witness siya? Ordinary witness ba siya or tinatawag natin na expert witness? Sige nga, sa comment section. Again, ang scenario, si medical doctor o yung physician natin, nung habang pauwi siya o nadatnan niya or nakita niya yung si Mr. A na sinasaksak si Mr. B. So ano ngayon, okay? So anong i-label natin? Anong kind of witness siya, class? Sige, lahat magsagot. Of course, he is very good. So, student ko talaga kayo. Okay. Of course, class, kahit medical doctor siya or given na medical doctor siya, of course, still, kasi magte-testify siya na, magte-testify lang naman siya based sa nakita niya or na-observe niyan. Okay, na sinasaksak ni Mr. A si Mr. B. So that's why he is labeled as an ordinary witness. Okay? He is an ordinary witness. Okay, nakuha ba? Okay, very good. So how about naman, okay, kapag yung physician na yung class, pinatawag ng korte, then magte-testify siya ngayon based on how deep or gaano kalalim yung tinatawag natin na wound, okay? Yung sugat ng ating or ng sugat ng biktima natin. Again, okay, relative to that scenario, yung physician or yung doctor, pinatawag ngayon ng korte kasi nga magte-testify siya based sa lalim ng sugat na natamo ni Mr. B. Okay, so anong kind of witness naman siya, class? Okay, so lahat sumagot. Okay, so very good. Of course, class, kailangan na doon ng tinatawag natin na CT. The skills, experience, training, expertise, or education. So that's why CT siya, class. Okay? Expert witness. Okay? So again, ulitin natin. Kapag magte-testify ka sa court based on the hymn or the handwriting, the identity of the person, and the mental sanity of the person, ang tawag sa iyo is the ordinary witness. While kapag kinakailangan ng korte na magta-testify ka based on CT, meaning ng CT, skills, we have the experience, the training, and of course, the education or expertise. Then of course, ang tawag natin sa iyo is an expert witness. Okay? Ang tawag na natin sa iyo is an expert witness. Okay? So I hope it's clear. Nakuha ba? Naiintindihan ba, class, yung kaibahan ni expert and ordinary witness? Nakuha? Kasi sa ibang mga students yun, kapag ganun, ang sagot nila agad doon, expert witness. Kasi nga, hindi nila nalaman. Okay, hindi nila nalaman. Actually, sa mga top university na napuntahan ko, kapag itananong ko yon, hindi nila talaga agad makuha. Kasi ang isasagot nila agad doon is what we call yung expert, kasi doctor daw. But of course, nung na-explain ko na, so doon nila nalaman na, ay, ganun pala. O di ba, kahit ang gagaling ng school nila or kahit mga top performing school sila, class, hindi nila alam yung ganun. But I'm very happy na alam ninyo or kasi nga you are my student. So that's why. So yun yung advantage ninyo. Kasi syempre kapag class, kapag yung mag-handle, hindi yan sila mag-go deeper. Okay, kapag sabihin nila, oh, okay na yan, ordinary witness, expert, so ganoon na lang, di ba? Hindi tapos pagdating sa board exam, bakit nababagsak ang student? Kasi nga hindi niya alam ang concept, di ba? Kahit bigyan mo siya ng 1,000 questions every day, sagutin niya, babagsak pa rin yan. Kasi nga hindi hindi niya alam ang concept. Kaya hindi effective yung lahat Q&A na lang, Q&A, ganito ganyan. Dapat 80%, okay, yung preparation mo sa board exam class, nakafocus yan sa information. Okay? Information. Then yung mga mock board, yung mga Q&A, okay? So dapat 20% lang ang meron ka. Kasi nga, of course, wala ka namang isasagot class kung hindi ka nagbasa, di ba? Read everything and know everything, di ba palaging sinasabi? Kasi nga, experience is the best teacher. Kung wala kang nabasa or kulang yung pagkaintindi mo ng concept na yan, wala rin, useless rin pagdating ng question, di ba? Mas maganda yon na loaded ka ng question. Okay? Hindi ibig sabihin na quantity, dapat wag kang maano doon. Dapat quality ang laman ng utak mo. Okay? Quality not quantity. Then of course, the strategy. Kasi again, daig ng madiskarte ang matalino. So, ayan. So, yan yung palagi nating sinasabi na of course kapag matalino ka kasi ayaw kang turuan, di ba? So, ganoon. So, ayan, witness ang sagot natin yan. Again, ulitin natin, pag sinabi natin evidence, na-explain na natin kagabi, i-review na natin, it is the means sanctioned by these rules, ascertaining in a judicial proceeding the truth respecting a matter of facts. Then, of course, ang quasi-courts, sa review lang, pag sinabi natin quasi-courts, they are not actually courts, but they conduct trial and hearing, okay, to settle controversy or to settle cases. Quasi-courts ang tawag natin dyan. Okay? Then, ayan, natapos na natin yung evidence. Take note, ang scope ng evidence is the same in all courts and all trials and hearings. Okay? So, of course, we have the admissibility of evidence. We have the relevant, ibig sabihin, connected or related to the issue, to the case or controversy. The number 2, not excluded by the law of these rules. Ibig sabihin, not excluded, tinatanggap. Ibig sabihin, competent. Okay? So, competent ang tawag natin dyan. Then, of course, we have the relevancy. And of course, we have the evidence on collateral matters. Ang evidence on collateral matters class shall not be allowed, of course, except when it tends in any reasonable degree to establish the probability or improbability of the facts and issue kasi nga, wala tayong term na tinatawag na irrelevant evidence. So, meron lang tayong collateral matters. So, pag sabi ng relevant, of course, connected to the issue, while ang collateral matters naman, it is outside of the controversy or meaning, it is not connected to the issue or to the case or to the controversy. Again, there's no such thing as what they call the irrelevant evidence. Meron lang tayong collateral matters. Then, wala rin tayong tinatawag na criminal evidence, meron lang tayong evidence. Of course, we have the criminal procedure, pero wala tayong tinatawag na criminal evidence. So I hope it's clear. Then, of course, we have the 3 kinds of evidence. So na-explain na natin to kagabi. So we have the acronym na ginagamit dyan, the orthodox. Kasi di ba, we have the object or yung tinatawag na natin na real or a topic preference. Tandaan nyo lang sa object, real, or topic preference again, it is addressed to the senses of the court or it is the highest order of evidence. Ibig sabihin, siya yung pinakamataas na value when it comes sa classification or sa kinds of evidence. Then of course, kasunod yan, we have the testimonial or oral evidence. Ibig sabihin, i-offer mo yun yung evidence through narration of facts or narration of circumstances or scenarios na nangyari. Okay? So, of course, through the witness. Aside from that, of course, yung deposition or yung affidavit na ginawa ng witness. Okay? Halimbawa, hindi siya makapag-testify orally. So, isusulat niya na lang ngayon ang tinatawag natin na kaniyang testimony or kaniyang evidence. Okay? So, yan yung testimonial evidence. And of course, the list or yung pinaka-last, we have the documentary evidence. Tandaan nyo lang sa documentary evidence kasi di ba ang haba, it is any writing, materials containing letters, words, numbers, figures, symbols, or other modes of written expression. But then again, ang focus nyo dapat sa class, dito kayo mag-focus, it is offered or it is offered as proof of their contents. Okay, it is offered as proof of their contents. While the object, real or topic preference naman, it is addressed to the censors of the court while ang testimonial, of course, it is the narration of facts or circumstances. So, tandaan niyo ang pagkakasunod-sunod ng tinatawag natin na order of evidence or sino yung mas pinakapangyarihan or mas pinakamataas na value. Of course, una, we have the object evidence, kasunod si testimonial evidence, and of course, the least consideration or yung last is the documentary evidence. Kasi nga, for the reason na pwedeng ma-alter diyan, pwedeng ma-doctor diyan, pwedeng mabawasan, pwedeng madagdagan. So that's why ang documentary evidence is the least consideration or yung least value. Okay. So least value class pagdating sa tinatawag na rin na order of evidence. Okay, so si Bridget. Okay, so baka ano yung signal na Bridget kagabi? Okay. So again, ulitin natin ang una nating yung sorry. Yung tamang, ngayon yun lang nalaman ang pagkakasunod-sunod. Hindi ba naturo nung undergrad ninyo? Patay. Okay. So don't worry kasi matatakal natin ulit yan sa court testimony. Again, ulitin natin, ang pinaka-highest order of evidence class, ang una natin, ang pinakamataas na value dyan is what we call the object. Kinds lang talaga, sir, alam ko, patay. So kasi class, yung mga alam ninyo, o yung mga tinuro sa inyo that is surface knowledge. Ibig sabihin, hanggang dito lang yan. Hindi sila nag-go deeper. Pero ang board exam, go deeper yan class. Sa yung pinakamababa talaga, yung mga pinakadetalye, dapat alam niyo yun. So that's why every time na nagle-lecture ako, as much as possible, dapat detailed tayo. Okay? Kasi detail is very important. Okay. So kasi dyan ako nakilala yung pag-explain, yung topic, sinasimplify ko, then detailed na agad-agad. So, hindi na kailangan pumunta sa Mars, di ba? Okay, para maintindihan ninyo. Okay, so again, the order of evidence class, ang pagkakasunod-sunod niya, we have the object evidence kasi siya yung pinakamataas. Of course, halimbawa, kapag i-present mo yung dead body, okay, ibig sabihin, that is addressed to the center, or yung firearm na ginamit niya, so siya yung pinakamataas na bibigyan ng consideration. So next, kasunod of course the testimonial evidence, and of course yung pinaka-least is the documentary evidence. Kasi nga, sabi ko, pwedeng ma-doctor yan, pwedeng madagdagan, pwedeng mabawasan, ma-obliterate, or matinatawag natin na ma-falsify ang mga documents na yon. So that's why palaging siya yung pinaka-last on the order or yung the order of evidence. But of course, kapag pag-uusapan natin class, ang offer of evidence, kung paano siya ino-offer sa court, of course, ang first natin na ino-offer dyan is the testimonial evidence. Okay, siya yung witness magta-testify. Kasunod is the object evidence, and of course, yung pinaka-last, yung pinaka-last natin is the documentary evidence pa rin. Okay, so siya yung pinaka-last kasi of course, yun yung reason behind that. So, 3 kinds of evidence. Again, magkaiba ang kinds of evidence sa tinatawag natin na classification of evidence. Nare-discuss ko kagabi. Okay, di ba? So, we go in detail kagabi sa kinds or sa classification of evidence. Okay, so may question na dito sa 3 kinds of evidence class. Wala na bang tanong? Kasi mag-proceed na tayo sa next slide. Okay, so yan yung 3 kinds of evidence na sa orthodox. Okay, tandaan nyo yung orthodox. Okay, next. Of course, ito yung classification of evidence natin kagabi class na na-discuss natin kagabi. So we have the DC Comcore, Precon, Persicone. So we have the direct evidence and circumstantial evidence, cumulative and corroborative evidence, prima facie and conclusive evidence, primary evidence and secondary evidence, positive evidence and negative evidence. So that is the classification of evidence that we have discussed kagabi. Of course, balikan ninyo yung balikan ninyo yung video na pinasa ko gabi or yung recorded lecture natin kagabi kasi doon na-emphasize ko yun mabuti or I go deeper sa discussion doon kagabi. So, para mas maintindihan talaga ninyo yung classification of evidence. So, yun. Okay, so since some of the important topics or the basic topics in evidence we already discussed, so dito ngayon magkakaroon tayo ng tinatawag natin na exercises. Okay? So it is a scramble or matching type, kumbaga matching type. So dito sa kabila, ito yung pinaka-main terms. Then hahanapin nyo ngayon ang sagot dito sa ating sa kabilang linya. Okay, halimbawa, judicial notice. Ano ba yung judicial notice? Ang object evidence, documentary evidence, best evidence rule, secondary evidence, and parole evidence. Then, bibigyan ko kayo ng 5 minutes class to answer. Then, after that, i-check natin. So, number your paper 1 to 6. Then, ilagay ninyo sa comment section. Do not copy the answers of your classmate. Again, so do not copy the answer of your classmates. Sige, bibigyan ko kayo ng 5 minutes. Then nilagay ninyo, halimbawa, judicial notice. Ano bang judicial notice? Halimbawa, agreement to be reduced into writing and so on. Okay? Nakuha ba class? Nakuha ang instruction? Uh, naririnig nyo class? Naririnig ninyo? Baka nawala ako, hindi. Hindi naman?
Hindi, sir.
Sige, sige. Okay, bibigyan ko ng 5 minutes to answer. Then after that, i-discuss natin one by one. What is judicial notice? What is object evidence? And so on. Okay, sige. 5 minutes muna. Then after that, isasagutan natin one by one. I-close ko na lang yung camera. Okay, so 5 minutes to answer. Then after that, we will explain. Okay, so 2 minutes left, class. A5CE. Okay, so lahat mag-participate, guys. 3, 4. Okay, so saan yung iba? Okay, let's answer class. Okay, so tingnan ninyo kung tama yung sagot ninyo. Wait lang. Oh, bakit? Okay, nag-guard na naman. Okay, so please check your score or your answer kung tama, then isagutan na natin. Ilan ang score ninyo? 1 to 6. Ilan ang score ninyo? Nakuha nyo? Okay, so number 1, we have letter F. Number 2, B. 3A, letter D, C, and of course, letter E. Okay, very good. Si Sir Aljon, perfect. Si Sir Binoya, 1 mistake. Sino pa yung naka-perfect dito? Okay, 6. JB, 6. Okay, very good. Okay, so ayan. Okay, so ibig sabihin, naintindihan ninyo class ang subject natin. Okay, so kasi kapag hindi natin ano yon o hindi nyo naintindihan na mabuti, of course, hindi nyo makukuha yung tamang sagot. Okay, so nag-vision na naman ang ating camera. Okay, pag sinabi natin judicial notice, tanan nyo pag sinabi natin judicial notice rather, okay, it is letter F or it is the facts presented as evidence in court. So pag sinabi kasi natin judicial notice class, yung mga bagay na common knowledge, okay, there is common knowledge sa atin, sa public, as well as to the judge, yan yung tinatawag natin na judicial notice. Ibig sabihin, hindi natin na kailangan i-prove kay judge yan. Kasi halimbawa, wag mo sabihin kay judge na nasa Pilipinas tayo kasi that is a judicial notice or it is a part of judicial notice kasi nga nasa Pilipinas naman talaga tayo. Okay, so but of course, halimbawa, may mga bagay na hindi familiar kay judge or hindi alam ni judge yan kasi nga sa bagay, for sir, nagkamali pa sa 1 and 4. Okay lang yan. Ang importante, nakuha niyo yung tamang sagot. Again, pag sinabi natin judicial notice, hindi nyo na kailangan i-prove yan kay judge kasi nga alam niya na yan. Okay? Kasi nga, of course, tao rin si judge, but of course, kapag nagkataon yung mga bagay na hindi niya alam, of course, kailangan na natin ng judicial notice sa ngayon. Okay? Kailangan na natin ng judicial notice doon. Kasi nga, may mga bagay or may mga facts na hindi alam ni judge kasi nga ang buhay niya nandoon lang sa korte. So that's why kailangan niya ng tinatawag kailangan niya na rin ng tinatawag na judicial notice to prove yung judicial notice. So again, a judicial notice, that is facts presented as evidence in court. Then number 2, we have the object evidence. Ang object evidence, of course, it is the highest order of evidence. It is addressed to the senses of the court. Siya yung pinakamataas among the kinds of evidence. Then we have number 3, the documentary evidence. Ang documentary evidence, tandaan nyo, it is offered at the proof of their contents. Ibig sabihin, ang tinatanong ng batas is yung nilalaman ng document. So that's why it is a documentary evidence. Kasi kapag ang itanong ng batas is based on the content kapag content, of course, that is documentary evidence. Kapag existence of the document, that will be the documentary evidence. Okay, tandaan niyo yun. Then of course, number 4, we have the best evidence rule na na-explain ko na actually ito kagabi. Ang best evidence rule, of course, yung original document. Diba? Ang original document, walang kapantay or walang kapalit si original document. Then, papasok lang sa eksena si secondary evidence kapag in the absence of original document. That's why, if the original document is unavailable, papasok ngayon si secondary evidence. So that's why letter C ang sagot natin sa number 5. And of course, then we have the parole evidence rule. Pag sinabi natin parole evidence, ibig sabihin the agreement have been reduced into writing, that is parole evidence rule. Okay, so yun yung tanda ninyo. Again, ang secondary evidence, it is the original document is unavailable. Papasok ngayon sa eksena si secondary evidence when the original document is unavailable. Again, ang judicial notice, it is a facts presented as evidence. Ang object evidence, it is addressed to the senses of the court. Ang documentary evidence naman, offered as proof of their contents. Ang best evidence rule, original document. Ang number 5, secondary evidence, that is what we call original document is unavailable. And of course, the parole evidence rule naman, when the agreement have been reduced into writing. Coach, yung best evidence rule, pwede ba siyang tawaging primary evidence? Yes, of course. Okay, pwede nating tawagin yun, class, as primary evidence. Ibig sabihin siya yung pinakamataas rin. Of course, pag sinabi natin best evidence rule, class, yung original document. Halimbawa, ang tinatanong niya is the birth certificate. Ang original ng birth certificate, that is the best evidence. Yung photocopy, that is the secondary evidence. Ibig sabihin, yung photocopy na yun, class, kinoconsider din siya na original document kapag it is executed or na photocopy, class, on the same time. Okay, so yun yung kaibahan ng original at secondary evidence. Okay, so yon. Okay na ba? Okay ba, class? Naintindihan ninyo? Meron ba kayong tanong? Paki-comment sa comment section natin. Okay. Okay, so thank you. So next, meron tayong next exercise dito. Okay, so please answer. Bibigyan ko kayo ng another 5 minutes to 6:30. So bibigyan ka ng 5 minutes to answer. Number 1, witness. Number 2, disqualification by reason of marriage. Number 3, disqualification by reason of privilege communication. Number 4, parental and filial privilege. Number 5 naman, admission by silence. Okay, sige. Please answer 6:30, so 5 minutes to answer. Then we will discuss one by one. Okay, 2 minutes left, 2 minutes. CBA. Let's answer this one. Okay, so very good. Okay, please check kung tama yung sagot niyo, class. Okay, so ilan ang score ninyo out of 5? E, B, C, B, A. Okay, sa Leonard, 5 points. Okay. Bakit may 6 si 6 si Vizcara? Hanggang 5 lang tayo Okay, hanggang 5 lang Okay, so let's answer this one. I-explain natin one by one, class. Okay, pag sinabi nating witness, that is letter E. Okay, any person who can perceive and can make known their perception to others may become a witness. And of course, we have 5 pala, sir. Okay, so okay lang yan. Okay, so again, pag sinabi nating witness, any person who can perceive and perceiving and can make known their perception to others may become a witness. Of course, we have the two types of witness, the ordinary witness and the expert witness. The ordinary witness will testify based on him, based on handwriting, identity of the person, and of course, the mental sanity of the person. While the expert witness will testify based on CP, the skills, experience, training, and education. So yun, ang dalawang witness natin. Again, ang witness, any person who can perceive and perceiving and can make known their perception to others may become a witness. Second, disqualification by reason of marriage. Ibig sabihin, the husband nor the wife may testify or not allowed class to testify for or against the other. Ibig sabihin, hindi sila pwedeng mag-testify class against the other kasi nga by reason of marriage. Kasi di ba may sinumpaan sila class sa korte ay sa harap ng Diyos. For better and for worse, for richer and for poorer, till death do us part. So that's why yan yung disqualification by reason of marriage. So yan, the husband nor the wife are not allowed to testify against the other. Okay? So hindi sila pwedeng mag-testify class pag sa civil case, sir, disqualified din ba sir, pag marriage? Yes. Actually, kapag ang si Nasim, okay, kapag yung talks about the wedding or yung sa mga marriage, papasok talaga yan sa civil case. Papasok talaga yan sa civil case class. But of course, take note in every rule, there is an exemption. Kapag yung husband and wife ay magkalaban sa Sa kaso, halimbawa, yung concubinage and adultery, of course, ma-disqualify or makuha yan or hindi yan tatablan or hindi natin gagamitin yung disqualification by reason of marriage. Okay? So, yung husband, of course, or ang wife can testify against each other kapag sila yung magkalaban. Take note under the disqualification of marriage, general rule, they are not allowed or they cannot testify against each other kasi nga of course kasal sila or by reason of marriage, they are not allowed or they are disqualified to testify against each other. Ano mangyayari ngayon kapag sila yung magkalaban sa kaso? Of course, that's the time mawawala yung disqualification by reason of marriage clause. Since, of course, sila yung magkalaban sa kaso. Alam nga naman sino yung magte-testify against each other, kung di sila lang. Kasi nga, di ba, ang adultery and concubinage, tinatawag natin yan na private crime. Ibig sabihin nun, only the offended party or the offended husband or the offended wife can testify the case or can testify on the case. Nakuha ninyo? Naiintindihan nyo na, class? Of course,
Yes, sir.
okay. Of course, general rule, hindi sila pwedeng makatestify sa kanila. Pero, pag nagkataon na sila yung magkalaban, of course, wala sila maggagawa, class. Kailangan nilang ipagtanggol ang sarili nila, of course, para makonvict yung husband or makonvict yung wife. That is disqualification by reason of marriage. The number 3 naman, disqualification by reason of privileged communication. Okay, so disqualification by reason of privileged communication. So we have letter C, you cannot testify as to the matters learned in confidence. Okay, meron tayong tinatawag class na acronym na ginagamit dyan or yung mag-annotate na lang tayo dito. Okay. So, meron tayong tinatawag class dito sa number 3. Tandaan nyo disqualification by reason of privileged communication. Meron kaming ginagamit dyan na happy class. Okay, happy. Ano yung letter H class? Ibig sabihin, hindi ka pwedeng mag-testify against the other, yung pinag-usapan ninyo, kasi that is confidential. Okay? So, that is learn in confidence. Okay? Yung H class, the husband cannot testify against, okay? Against, of course, the wife. Tama, di ba? So, yun yung H. Okay, ano pa? Ano naman yung letter A? Ano naman yung letter A class? Okay, so ano yung letter A? Okay, kasi di ba the husband are not allowed or is not allowed to testify against the wife. How about naman yung tinatawag natin na na other P? Sino yung may idea? Okay, of course, the attorney and client. Very good. Attorney and client. Okay, hindi mo pwedeng i-divulge in class kasi nga pinag-usapan mo yan. Okay, so ano pa yung next? Yung letter P naman. Bakit ba? Akala mo. Okay, how about yung letter P? Okay, of course, we have the priest, di ba? Priest and penitent. Okay, the priest and penitent. So they are not allowed to testify. Okay, yung sinabi ng nagkumpisal, di ba? Yung nagkumpisal sorry. Yung nagkumpisal sa tinatawag natin na simbahan, of course, hindi mo yan pwedeng class. Hindi mo pwedeng i-divulge yan. Ano pa class? Priest and penitent. How about yung another P? Ano yung another P? Okay, public officer. Okay, public officer. Okay, public officer or police officer. Okay, how about yung yung letter I, public officer. Ano naman yung letter I? Ano yung letter I, class? Okay, sino may idea yung letter I, yung last na papasok sa tinatawag natin na privileged communication. Imam, walang imam Ano yung I, class? tingnan nyo nga sa under the rules of criminal procedure. Ay, rules of evidence rather. Okay, so nandyan pa ba kayo? Again, class, so ano yon? Intervention. Okay, again, diba? We have the husband and wife, the attorney, and of course, the client. Okay, the physician, and of course, yung tinatawag natin, okay, sorry. Ano yan physician, of course, the patient. Physician and patient, of course. Bakit pumunta kayo sa public officer? Okay, and patient. Ano pa yung isa? Ano pa yung isa? Okay, and of course, yung pinaka-last is what we call, okay, so, then of course, we have, anong institution siya? Okay, and of course, yung pinaka-last class is the public officer, okay, the public officer and public officer. Interest, kasi interest ang tawag natin dyan, class. Okay, so, interest, yung I, of course, interest, public officer. Sorry, and public officer. Ulitin natin. So again, so we have the reason or the privilege communication or disqualification by reason of privilege communication. Ibig sabihin dyan, so yung mga tao na nandyan, class, are not allowed to be examined or cannot testify as to the matters learned in confidence. Ibig sabihin, yung pinag-usapan ninyo, hanggang doon lang yan. Okay, halimbawa, yung husband or yung wife cannot testify or during the existence of marriage, class, hindi sila pwedeng mag-testify against each other except in a civil cases unless kapag yung kaso, class, is against each other. Then of course, we have the next, of course, the attorney. Hindi rin siya pwedeng ma-examine, class, o hindi rin siya pwedeng mag-testify laban sa kaniyang kliyente. Kasi nga, that is, may pinag-usapan sila, okay? Attorney and client. Then third, of course, the another P, okay? So we have the physician, okay? The physician and of course, the yung kanyang patient or yung pasyente niya. Then of course, we have the priest and penitent, okay? Yung minister or yung priest, yung tinatawag ninyo na imam, okay? Without the consent, yung tao na nagbigay ng kanyang confession, class, is not allowed, okay? Yung priest is not allowed to be examined. Okay, so yon yung at the priest and of course the penitent, and of course yung pinaka-last, yung public officer or yung tinatawag yung I, class, that stands for interest. Okay, interest, and of course that is ang trabaho niyan ni public officer. Okay, yung mga communication na pinag-usapan doon, hindi yan pwedeng i-divulge. Okay, ulitin natin. So we have the disqualification by reason of privileged communication. So we have the happy, the husband and wife, attorney and client, priest and penitent, physician and patient, and of course the interest or the public officer and interest. So yan yung disqualification by reason of privileged communication. Nakuha niyo ba, class? Nakuha ba? Naintindihan nyo na ngayon ang tinatawag natin na disqualification of by reason of privilege communication. Naintindihan nyo na ba?
Yes, sir.
Okay, sige.
Yes, sir.
Very good. So tandaan nyo ang ginagamit natin na acronym dyan is HAPPY. Okay, HAPPI. Okay, para mas madali ninyong mas madaling ma-retain sa utak ninyo. Then number 4, we have the parental and filial privilege. Okay, so sa number 4, we have the parental and filial privilege. So sa letter B yan, okay, you are not allowed, or the parents, kapag sinabi natin sa parental class, the parents are not allowed or cannot be testify against the children. Okay, so yan, sir, bakit interest ang last, sir? Sir, interest. Hindi. Anong ibig sabihin ni Bridget? Okay, sir, bakit interest ang last, sir? Kasi ito yung sinusundan natin, yung happy. Ayan o, happy. Okay, husband and wife, yung H, yung letter A, attorney and client, yung P, priest and penitent, yung another P, physician and patient, and of course yung I, that is public officer and interest. Okay, but of course unahin natin, ilalagay na lang natin yung I. Okay, so unahin natin ang interest and of course yung public officer. Hindi niyo na ba nasundan? Sige lang, balikan niyo ulit mamaya sa ating recorded lecture, recorded video rather, sorry. Okay, so yun, public officer, of course, and interest. Kung ano yung pinag-usapan, halimbawa, di ba, you are a public officer, yung police officer, kung ano yung pinag-usapan nyo doon sa community ng police or ng citizen at police, of course, hindi mo pwedeng i-divulge yan kapag walang consent ng citizen rin or ng tao na yon. Okay, so yun yung interest natin. Nakuha ba sino yan? Si Ma'am Bridget? Nakuha ba? Okay, so yan. So ayan. So ano na yan, mga mnemonics natin, okay? So yung para mas madali ninyong maintindihan. Okay? So happy. Okay, happy. So okay, next. Well, we have the okay, wala pa pala, hindi ko pala natapos, sorry. Okay, bakit sana yun? Okay, so dito tayo class sa parental. Okay, parental and filial privilege. Dalawa yan dalawa yan. Ang pag sinabi nating parental privilege, nakalagay di ba sa letter B. Okay, compelled to testify against. Okay, so pag sinabi nating parental privilege class, ibig sabihin yan, the parents, okay, hindi pwedeng mag-testify ang parents laban sa mga anak niya. Again, the parents are not allowed to be compelled or are not allowed to compelled or are not allowed or to compel to testify against their children or against their child. So that is the parental privilege. Ang filial privilege naman class, ang filial, ibig sabihin, the children or yung anak are not allowed or is not allowed to testify against their parents. Ulitin ko. Dalawa under the parental and filial privilege, dalawa yan. Ang parental privilege, ibig sabihin, the parents are not allowed to testify against their children, while ang filial privilege naman, the children are not allowed to testify against their parents. So vice versa. Then, of course, we have the number 5, the admission by silence. Ang admission by silence, ibig sabihin, the witness or the person being asked does not or does or says nothing. Wala talaga siyang response. So, nag-admit siya, but of course, in silence. Okay? Hindi siya nagbigay kung ano yung any verbal cues. So admission by silence ang tawag natin dyan. Ulitin natin. Pag sinabi natin witness, tandaan niyo that is any person who can perceive. Ibig sabihin, naiintindihan niya or ginagamit niya yung kaniyang deferent senses. So pwede siyang matawag or is qualified to become a witness. Any person who can perceive and perceiving and can make known their perception to others may become a witness, even the child, okay? Then of course, second, we have the disqualification of marriage. So letter D, the husband nor the wife are not allowed to testify or against the other. Kasi nga, by reason of marriage, kasi di ba may sinumpaan sila sa church, di ba? For better and for worse, for richer and for poorer, till death do us part. So that's why disqualified sila class to testify against each other. But of course, ang exemption to the rule, kapag sila yung magkalaban sa kaso, pwede silang mag-testify against each other. Disqualification by reason of marriage ang tawag natin dyan. Then third naman, disqualification by reason of privileged communication. Ibig sabihin, you cannot testify as to the matters learned in confidence, yung happy kanina. Yung pinag-usapan nyo ng husband and wife are not allowed. Attorney and client, hindi rin pwedeng i-divulge yan. Yung priest and penitent, hindi rin pwede. The physician and patient, kung ano yung pinag-usapan ninyo. Ano ba, may AIDS siya, okay? May, yung acquired immunodeficiency disease, di ba? Yung AIDS. So, hindi mo pwedeng i-divulge yan na may AIDS yung pasyente mo or yung patient mo. So, physician and patient ang tawag natin dyan. Then, of course, the the interest or the interest of the public. So that's why nagkaroon tayo ng public officer and interest. So unahin natin yung interest. So yan yung disqualification by reason of privileged communication. Then we have the parental and filial privilege. Ang parental and filial privilege class, the parents are not allowed or are disqualified to testify against their children. Hindi na pwede yan. Then ang filial naman, the children are not allowed to testify against their parents, vice versa. Then ang admission by silence, that is letter A, the witness or the person does or says nothing as a response. So ang tawag natin dyan is admission by silence. Okay, that is letter A. Okay, nakuha ba? Nasundan ninyo class? Nasundan?
Sir.
Okay, sige. Next. Sorry, balikan muna natin na hindi na erase para yung ano. Erase muna yung annotate natin. Clear. Okay, let's proceed now sa next slide. Okay, so pag sinabi nating testimony, what is testimony? What is dying declaration? What is part of res gestae? Number 4, expert witness. Number 5, ordinary witness. Number 6, burden of proof. Number 7, hearsay. Okay, so hanapin niyo ang sagot niyo dito. So number your paper 1 to 7. So kasi 7 yan, so magbibigay ako ng 7 minutes to answer the question. Okay, your timer starts now, class. Then after that, i-explain natin rin one by one. Okay, so let's answer this one. Okay, so please check kung tama yung mga sagutin nyo. Okay, so of course, number 1, testimony. Number 2, dying declaration. Number 3, part of rest stay. Number 4, expert witness. Number 5, ordinary witness. Number 6, burden of proof and presumption. And of course, number 7, hearsay naman. Okay, ilan ang scores ninyo, class? Pakibilang. F2, FE, B, 7. Okay, very good. Okay, si Nasim, 5/7. Si Sevelina, 7. Very good. Okay. So, i-explain natin to one by one, class. Okay, so pag sinabi nating testimony, of course, that is letter F. That is based on personal knowledge. Again, pag sinabi nating testimony, that is letter F. Naka-base yan sa personal knowledge. Kasi di ba kapag nagte-testify tayo sa court, ibig sabihin, alam natin yung sinasabi natin or ibig sabihin, hindi natin yan narinig sa ibang tao. So that is what we call the testimony that is based on personal knowledge of person. So hindi tayo pwede mag-testify, class, based sa tinatawag natin na hearsay or narinig lang natin sa ibang tao. Sorry. So again, ang testimony, magte-testify tayo based on our personal knowledge of the event or kung ano yung nakita natin. So that is a testimony. Then second, we have the dying declaration. Okay, ang dying declaration, okay, that is the declaration of a dying person kung sino yung pumatay sa kanya. Halimbawa, kung sino yung bumaril sa kanya, sino yung tinatawag natin na sumaksak sa kanya, that is dying declaration. Tandaan ninyo, ang sa dying declaration on the occurrence of death, ibig sabihin, nasa bingit na siya ng kamatayan. So, ang tawag natin dyan is dying declaration. That is the declaration of a dying person kung sino yung bumarel or kung sino yung pumatay sa kanya. So, that is dying declaration, class. Okay, very good. So, tandaan ninyo, ang dying declaration, again, di ba, that is the declaration of a dying person kung sino ang pumatay sa kanya or sino yung sumaksak sa kanya. Kapag nagkataon, class, na sinabi sa iyo, halimbawa, sinabi ni Mr. A, nung naghihingalo na siya, sinabi ni Mr. A na ganito, si Cardo Dalisay ang pumatay sa akin. Okay, so sa dying declaration ang tawag natin doon, class, kung ano yung sinabi ng dying person or yung mamamatay na tao, ang tawag natin doon is dying declaration. Okay, so ano yung mangyayari, sir, kapag nagkataon na buhay si Mr. A? Okay, kapag nabuhay si Mr. A, class, ang statement niya o yung mga sinabi niya, class, it will always be or it will be part of the res gestae. Again, magiging parte lang to ng tinatawag natin na res gestae. So meaning, it is the statements of the starting occurrence. Ibig sabihin, nung 50-50 siya, okay, ibig sabihin, yung 50-50 siya, class, or ibig sabihin naghihingalo na siya, ang tawag natin doon is dying declaration. Di ba sinabi niya na ang pumatay sa kanya is si Cardo Dalisay. Pero hindi niya alam, okay, naagapan pa nung dinala sa hospital. So ang statement niya na yung statement niya na ngayon, class, is it will be part of the res gestae. Again, it will be part of the res gestae. Magiging dito na yan siya papasok, class, sa number 3. Okay? So it will be part of the res gestae. Then, of course, we have the expert witness. Ang expert witness, magte-testify yan based on CT. Of course, we have the skills, experience, training, education, or expertise. Then, of course, the ordinary witness naman, magte-testify yan ngayon based on him, okay? Based on handwriting of the person, based on the identity of the person, and of course, the mental sanity of the person. So dyan magte-testify ang ordinary witness. Then of course, the number 6, we have the burden of proof and presumption na tinatawag natin. So sa burden of proof and presumption, kailangan natin ang tinatawag natin na onus probandi. Okay, ang onus probandi, or that is the burden of proof. Okay, ito burden of proof, okay, and presumption to convict a person. Ang tawag natin dyan is onus probandi. Okay, so onus probandi ang tawag natin dyan, or burden of proof. That is letter C. So, tanda nyo, class, ang burden of proofs. Okay, sino yung may burden of proof in a criminal cases, class? Okay, kung alam nyo pa. Sino ang may burden of proof in criminal cases or may onus probandi? Kasi di ba, we have the prosecution party and the defense party. So sino sa kanila ang may burden of proof ngayon? Okay, sino ang may burden of proof? Okay, so ang may burden of proof and presumption, okay, very good. Of course, class, si prosecution ang may burden of proof and presumption. Okay? Siya yung tinatawag natin na may burden of proof and presumption. So again, how about naman kapag nagkataon na reverse trial? Halimbawa, nag-claim siya ng self-defense. Okay, nag-claim siya ng self-defense. So saan naman ngayon ang may burden of proof and presumption? Okay, sino naman ngayon ang may burden of proof and presumption kapag yung tao is nag-claim ng self-defense? Okay, very good. Of course, it will be on the part of the defense party. So ayan, very good kasi alam nyo na. So it will be part or ang may burden of proof and presumption ngayon kapag what they call the reverse trial is of course, the defense party. Okay. Okay, so very good. So next, again, pag sinabi nating burden of proof and presumption, yan yung tinatawag natin, of course, the onus probandi. Again, general rule ang may onus probandi or may burden of proof na guilty yung tao is lies on the prosecution party. Kapag naman reverse trial, of course, papasok yan ngayon sa tinatawag natin na defense party. Then, of course, we have the hearsay. Okay, ang hearsay naman, tandaan nyo, bawal ang hearsay. Okay, bawal ang hearsay. That is out of court statement. So, meaning, hindi siya connected sa kaso. Okay, hindi siya connected sa kaso. Ibig sabihin, hindi niya narinig mismo yung statement na yan or yung pinag-uusapan na yan. So, that's why it will be part of the hearsay. So, again, general rule in court, hindi tayo or hindi tinatanggap ng korte class ang hearsay evidence. So, but of course, ang exemption to the hearsay rule, we have the dying declaration and of course the res gestae. Okay, again, tandaan niyo kapag nagte-testify tayo sa korte, Pag nagte-testify tayo class in korte, dapat based on our personal knowledge. Ibig sabihin, tayo mismo yung nakarinig niyan or tayo mismo yung naka-witness, hindi yung narinig natin sa ibang tao kasi nga hindi yan siya papasok. Hearsay yan. Meaning it is only chismis. Okay, di ba? Chismis lang yan ang tawag natin dyan. So that is not allowed under the law or under the rules of court. Ulitin natin as a summary, pag sinabi nating testimony, that is, of course, that is based on personal knowledge. Ang dying declaration naman, that is declaration of a dying person. Number 3, part of the res gestae, that is the statements of the person or starting occurrence. Tandaan niyo kapag namatay siya, of course, ang statement na yon, it is a dying declaration. Kapag nabuhay naman siya, it will only be part of the res gestae. Okay? So, meaning nabuhay siya. So, res gestae na lang. So, kasi useless na yun kasi nabuhay siya klase. So, hindi na magagamit yung dying declaration niya kung sino yung pumatay sa kanya. But then, of course, we have the expert witness. Magte-testify siya based on CT. Ang ordinary witness naman, magte-testify siya based on him. Ang burden of proof and presumption, of course, ang may burden of proof and presumption sa ating class is, or yung tinatawag natin na unus probandi, or that is always lies on the prosecution, while naman, ang may burden of proof and presumption kapag what we call the reverse trial is nakasalalay yan sa tinatawag natin na defense party. Okay? Then of course, ang hearsay that is not allowed kasi nga it is a out of court statement. So it is not allowed. Nakuha ba? Nakuha, class? Nakuha nyo, class? Nakuha?
Yes, sir.
Okay. Okay, very good. Okay, so yan. Okay, so dapat quality tayo, class. Nasa quality. Okay, of course. Let's proceed now sa next tayo. Okay, so number 1, we have direct examination. Number 2, cross-examination. Number 3, redirect examination. Number 4, Recross examination number 5, misleading question. Okay, you can start answering on the comment section. So bibigyan ko kayo ng um, okay, 10 minutes. 10 minutes to answer. Okay, so let's discuss class. So please check kung tama yung sagot ninyo. Okay, so ilan ang score ninyo? Okay, so pag sinabi nating direct evidence, okay, direct examination rather, so number 1, that is letter B. Okay, tandaan niyo kapag direct examination, tinatawag natin yan na examination in chief. Okay, tandaan niyo tandaan niyo ang direct examination, of course, tinatawag natin yan na examination in chief. Okay, very good. Nasim 5/5. Yung iba, ilan ang scores ninyo? Tandaan nyo again, ang direct evidence, it is the examining vibrancy Biscara. How about others? Okay, very good. So again, pag sinabi natin direct evidence, tinatawag natin yan na examination in chief of a witness. So yan yung pinaka-start natin class on the examination of witness. Kasunod naman, we have the cross-examination. Okay, again kasi yung pinaka-first, we have the direct. Second naman, we have the cross-examination. Ang cross-examination, that is letter A, meaning it is the matter stated in the direct examination. So ibig sabihin, ang itatanong mo dito during the examination is yung mga nabanggit ng kalaban mo or yung sa kabilang partido or kabilang party during the direct examination. So the matter stated in the direct examination, so yun yung mga tatanungin class on the cross-examination. Then we have, of course, pag after ng cross-examination class, susunod na yan yung tinatawag natin na redirect examination. Ang redirect examination meaning, i-explain mo ngayon or isusupplement ngayon yung mga answers given dito or given or nabinigay mo during the direct examination. Kaya nagkaroon tayo ng redirect. Ibig sabihin, yung re kasi na word or yung term na re, ibig sabihin again. Kaya nagkaroon tayo ng redirect examination. Ibig sabihin, you must explain or supplement your answers given sa time na tinatawag natin na direct examination. And of course, we have the recross examination. Sa recross examination, of course, that is letter D, yung mga matter stated during the redirect examination, yun yung mga itatanong mo. Kaya nagkaroon tayo ng recross examination. Again, class, una dyan, in the examination of witness, meron tayong direct examination. Tinatawag natin yan na examination in chief of a witness. Ang cross-examination naman, ang itatanong mo dyan, yung mga matters stated in the direct examination. While in the redirect examination class, of course, ang i-explain mo or isusupplement mo ngayon yung mga answers or mga sagot mo given during, of course, the cross-examination. So, ang tanong ko ngayon, class, sino ang nagkakandak ng direct examination? Okay, again, sino yung nagkakandak ng direct examination? On the comment section, sino nga po or sino nga ba ang nagkakandak ng tinatawag natin na direct examination? Sige nga. Sorry. Again, sino ang nagkakandak ng direct examination? On the comment section, please. Again, sino yung nagkakandak ng direct examination? Bakit walang sumasagot? Again, sino ngayon ang nagkakandak ng direct examination? Bakit walang sumasagot? Narinig niyo pa ba ako? Defense? Ano pa? Ano pa yung mga sagot? Defense. Okay, prosecutor. Sige nga, yung mga binanggit nyo class na sagot, wala doon. Walang defense walang prosecutor kapag direct examination. Sino yung nagkakandak niyan? Attorney, wala rin. Okay. Another try.
Fiscal.
Clerk? Judge? Bakit walang mga sagot yung mga sagot nyo class? Hindi kayo familiar dito? Witness? Hindi rin. Bakit si clerk? Bakit may clerk? Bakit kaya si clerk?
No idea, sir.
No idea? Wala talaga kayong idea? Okay. So, tandaan ninyo, the Council of the Defense Party. Ito na lang, bibigyan ko ng mnemonics dito sa ano. Direct, cross, redirect, and of course, recross. Tandaan nyo tong ano. Ayan. DCRR, POPO. Again, tandaan niyo ang nagkakandak ng direct examination is si, okay, proponent. Sa cross-examination, okay, hindi nyo talaga binabasa yung notes na binigay ko sa inyo, ha? Ang nagkakandak ng cross-examination is the opponent. Bakit nakaabot kayo kay ano kanina? Kay clerk of court. Redirect examination naman, si proponent pa rin. Okay? Then ang recross examination is si, okay, opponent. Nakuha? Again, pag sinabi natin DCRR or DCRR, ang direct examination class, ang gumagawa niyan is the proponent. Ang cross-examination naman, opponent. Ang redirect examination, si proponent. Ang recross naman is of course the opponent. Nakuha nyo na? Bakit umabot kayo kay clerk of court, kay judge? Sino pa yon? Yung mga binanggit ninyo? Investigator, counsel. Okay, di ba? Wala talaga isa do. Okay, so again, ang tanda nyo lang na acronym class is DCRR POPO. Direct examination by proponent, cross-examination by opponent, redirect by proponent, and recross by opponent. Nakuha ba? Nakuha ninyo? Or hindi pa rin? Okay, very good. So again, tandaan niyo ang gumagawa or nag-execute ng direct examination, of course, si proponent. Sa cross-examination naman, si opponent, sa redirect, the proponent pa rin, and of course, ang recross sa opponent. So yun yung tandaan niyo, ha? DCRR, POPO. Then, of course, we have the misleading question dito. Ang misleading question, of course, that is assumes as true or facts not yet testified. Tinatawag natin yan ngayon na misleading question. Again, ang misleading question assumes facts not yet testified. That is what we call the misleading question. Nakuha ba? Nakuha ninyo?
Yes, sir. Yes, sir.
Okay, so ayan. So
So,
yan yung mga ano natin. So I hope nakuha ninyo, ha. So para hindi tayo babalik. I-review ulit ninyo class yung ating yung ating video or yung ating recorded lecture. Then of course, yung files na pinasa ko doon sa inyo sa criminal law. So dapat basahin niyo na yun, ha. Okay. Then of course, another batch or another ano. So, in a criminal case, ano yung kailangan natin? In a civil case, ano yung kailangan natin? In administrative case or quasi-bodies. Number 4, indemnification. Number 5, reparation naman. Sige, go ahead. Okay, 7 to 10 minutes. Okay. Then after that, we will answer. Okay, so let's try to answer this one, class. Okay, please check your score. Then, sige, ilan ang score niyo? Then, i-explain natin one by one. Okay, 5. Very good. Okay, so sino yung nakakuha? Okay, so very good. So again, we have number 1. Okay, we have the criminal case, that is letter B. So that is proof beyond reasonable doubt. Take note, class, meron tayong tatlo na tinatawag in criminal case, in civil case, and of course in administrative case. Ang tawag natin dyan, weight or sufficiency of evidence needed to convict a person in the different cases. Ang tawag rin natin dyan, tinatawag rin natin yan na quantum of evidence. Of course, number 1, we have in criminal case. Of course, in criminal case, we have letter B. Okay, so before natin makonvict yung person, of course, kailangan natin ng proof beyond reasonable doubt. Again, in a criminal case, we have the proof beyond reasonable doubt. Ibig sabihin, kailangan natin ng matibay na ebidensya, okay, para mapatunayan, okay, or proof beyond reasonable doubt, or enough proof na masabi ng korte na nagkasala talaga yung tao na yon. Then second, on the civil case naman, we have the letter A, or yung tinatawag natin na preponderance of evidence. Ibig sabihin, paramihan or yung pabigatan ng ebidensya. Okay? So yan, case sir, kapag sa PI is probable cause ba? Hindi. Iba naman ang probable cause, class. Pag sinabi natin in criminal case, kailangan natin ng proof beyond reasonable doubt. Ibig sabihin, before sa ma-convict, class, ng korte, kailangan muna makitaan ng enough proof or evidence ang tao na yon before siya tawagin na guilty beyond reasonable doubt. Ang probable cause na tinatawag ninyo, of course, kailangan natin ng PI yan, class. Ang probable cause, kailangan natin yan, class, kapag in the issuance of warrant of arrest. Tandaan niyo ang probable cause, again, kailangan natin yan during the issuance of warrant of arrest. Kapag merong probable cause, of course, mag-i-issue yung judge ng tinatawag natin na warrant of arrest. Kung wala, hindi. I-dismiss niya yung kaso. Dito naman, ang pinag-uusapan natin dito na proof beyond reasonable doubt, nasa korte na yan, class. Ibig sabihin, tinatrial and hearing na natin yung tao na yon or yung akusado natin. So in a criminal case, kailangan natin ng proof beyond reasonable doubt or enough proof na masasabi natin na, okay, the person is, of course, what we call the, merong enough proof na magpatunay na nakagawa siya ng krimen or siya talaga yung gumawa ng krimen. So in a criminal case yan. Then in a civil case, kailangan natin ng preponderance of evidence. Ibig sabihin, pabigatan ng ebidensya by both parties, ng defense or ng prosecution party. Then of course, number 3, so we have letter C, the substantial evidence in administrative cases or in the quasi bodies. Ibig sabihin, substantial or enough evidence to convict a person. So yan, again, pag sinabi natin in criminal case, kailangan natin, or before natin makonvict yung tao na yon, kailangan natin ang tinatawag natin na proof beyond reasonable doubt. In administrative case naman, kailangan natin ng substantial evidence. In civil case, kailangan natin ng preponderance of evidence. Then number 4, we have the indemnification. Okay, sa indemnification, of course, class, papasok dito ngayon sa tinatawag natin na civil liability. Again, when a person is criminally liable, he is also civilly liable. Ang indemnification, of course, that is letter D, ibig sabihin, you compensate. Ibig sabihin, kung ano yung nasira mo or yung nanakaw mo, class, babayaran mo yun kasi it is part of indemnification. Then, ang reparation naman, ibig sabihin, you restore or i-repair mo ngayon ang nasira mo. Halimbawa, nagnakaw ka, class, tapos sinira mo yung bakod nila, of course, kailangan mo restore yon. Okay? So, yan yung tinatawag natin na reparation. Again, in a criminal case, kailangan natin ng proof beyond reasonable doubt. In civil case naman, kailangan natin ngayon ng preponderance of evidence. In administrative case, kailangan natin ng substantial evidence. In indemnification, kailangan natin, of course, i-compensate or bayaran yung mga nasira mo And of course, ang reparation naman is to restore. So, in criminal case kapag ang accused ay nag-claim ng justifying or exempting circumstance. Ha? Ano ba? In criminal case kapag ang accused ay nag-claim ng justifying or exempting circumstance. And then, na-discuss na natin yan class sa book 1. Okay, kung hindi nyo nakita yung book 1 class, ng mga circumstances, balikan nyo lang. Of course, ano yan, nakadepende na yan sa korte kung i-honor niya o hindi. Then of course, during trial na yan class, yung circumstances na yan, whether it is justifying or exempting, papasok na yan doon. So yung hindi nakaabot ng book 1, balikan niyo ang book 1 na discussion natin para mas maintindihan niyo ang mga din-discuss natin dito. Okay? So baka hindi kayo nakaabot. Again, so we have the weight and sufficiency of evidence needed to convict a person or yung tinatawag natin na quantum of evidence. In a criminal case, kailangan natin ng proof beyond reasonable doubt. In a civil case naman, kailangan natin ng preponderance of evidence. In administrative case, kailangan natin ng substantial evidence or enough evidence to convict a person. In indemnification, of course, kailangan natin i-compensate or kailangan natin bayaran yung mga danyos or mga damages na sa paggawa mo ng krimen. And in reparation naman, kailangan natin i-restore or of course, yung nasira mo class. So it is part of the civil liability. Nakuha ba? Nakuha class? Nakuha ninyo?
Yes, sir.
Okay, good. Then next tayo. Yung hindi nakaabot ng mga book 1 class, CGS and so on, pwede nyong balikan. Okay, so ayan. So natapos na natin ang evidence actually. But of course, we will discuss yung duration of penalties. So I hope para mag-proceed tayo sa book 2, ready na tayo. Okay, so again, so we have the PT McCord, AMA-AME. So again, ito yung ating sa duration of penalties natin class. Tandaan niyo, we have the PT McCord, AMA-AME. So we have the PE, of course, perpetua, yung T naman, temporal, yung MA, mayor, for correctional, yung D, destiero, yung AMA, okay, then of course, AME. Okay, so sige, ano nga, okay, lagay ng sagot ninyo class sa comment section kung ilang years ang repression perpetua, ilang years sa temporal, presyon mayor, presyon correctional, destiero, arresto mayor, arresto minor. Okay, balik. Okay. And of course, yan lang sila class. Okay, 1, 2, 3, 4, 5, 6, 7. Okay. Number your paper 1 to 7, then ipa-flash natin ang sagot mamaya. Don't forget yung plus 1 day in every examination. Huwag kayong tumingin sa Google or sa any yung sa notes niyo. Okay? So, ilang years si perpetua, si temporal, mayor, correctional, destiero, arresto mayor, and arresto minor. Okay, so your timer starts now. Okay, bibigyan kayo ng 8 minutes. Okay, so tatlo pa lang ang sumagot, class. Saan yung iba? Okay, so saan yung iba? So another uh 3 minutes, 3 minutes left. Okay, so please check your answer kung tama. Okay, so again, under the Article 26 or under the duration of penalties, so again, we have the pitim accord, ama-ame. So ang reclusion perpetua, that is 20 years plus 1 day to 40 years. While ang reclusion temporal, that is 12 years plus 1 day to 20 years. Ang prison mayor naman, that is 6 years plus 1 day to 12 years. Ang prison correctional, that is 6 months plus 1 day to 6 years. Ang destiero, of course, that is 25-kilometer radius. Ang arresto mayor, that is 1 month plus 1 day, plus may plus 1 day pa dito kasi, plus 1 day. Plus 1 day to 6 months. Then, of course, the arresto minor naman, we have the 1 day to 30 days. Again, ulitin natin. So, we have the duration of penalty. So, we have the pitim accord, ama-ame. Ang reclusion perpetua, that is 20 years plus 1 day to 40 years. Ang reclusion temporal naman, 12 years plus 1 day to 20 years. Prison mayor, that is 6 years plus 1 day to 12 years. Prison correctional, 6 months plus 1 day to 6 years. Arresto mayor, that is 1 month to 6 months. And arresto minor, that is 1 day to 30 days. Okay, ilan ang score ninyo? Ilan ang score ninyo? Plus, okay, plus 1 day, plus 1 day. Plus 1 day ang gamit natin ha. Okay, very good. So, ayan. Plus or and pwede rin. Okay? So, plus or and pwede mong gamitin. Plus 1 day. Or, kasi nga, very important yung plus 1 class. Okay? Actually, sa bakit kaya very important yung plus 1? Kasi nga, it will divide every penalty. Kapag walang plus 1 yan, iisa lang yan. So, ayan, very good. So, again, very important yung may plus 1 ha. Kasi it will divide every penalty. Okay? So, yun yung tinatawag natin na plus 1 in every penalty. Okay? 7. So, ayan. So, very good. Dito tayo. Okay, so before tayo mag-end, of course, nakuha nyo na yung yung duration of penalties para bukas mag-start na tayo class sa book 2 natin. Okay, dito sa death penalty class, meron tayong 3 death penalty na na-implement sa Pilipinas. Ang acronym or keywords or mnemonics na sundin nyo lang dyan is the RLA 789. Okay, the RLA 789. Okay, so again, under the death penalty, so we have the RLA 789. So ang reimposition of the death penalty, of course, we have the Republic Act 7659 or yung tinatawag natin na reimposition. So that's why ang tanda niya lang the letter dyan is letter R. Then we have the RA 8177. So yan yung tinatawag natin na lethal injection. Okay, ano yung ginagamit natin class na chemical or substance na tinuturok during the lethal injection or death penalty by lethal injection. Okay, paki-comment sa ating chat box. Ano yung chemical or ano yung substance na ginagamit natin in the lethal injection or death penalty by lethal injection? Paki-comment sa comment section. Sige. Bromide. Bakit may bromide? Okay, very good. So ang chemical na ginagamit natin diyan is sodium thiopental or sodium pentotal or pentotal lang. Okay, that is the chemical or yung substance na ginagamit natin in the lethal injection. Okay, so 8177. Then of course, we have the Republic Act 9346, that is the abolition of the death penalty in the Philippines. Kaya wala tayong death penalty ngayon sa Pilipinas class because of this law. yung Republic Act 9346. So, Republic Act 7659, that is the reimposition of death penalty. 8177 naman, that is the death penalty through lethal injection. And of course, we have the Republic Act 9346, that is the abolition of the death penalty in the Philippines. So again, wala tayong death penalty sa Pilipinas. So meaning, kapag nahatulan ka ng death penalty, automatic class, ang ibibigay sa inyo na punishment is whether it is life imprisonment or reclusion perpetua. So ang tanda nyo lang, kapag death penalty is RLA 789. Okay? So natapos na natin ang evidence class. So bukas mag-start na tayo sa Criminal Law Book 2. So dapat wala mag-absent bukas kasi ang Book 2 ang pinaka-importante sa board exam kasi 35 questions manggagaling doon sa Book 2 natin. So pag-uusapan natin yung mga different crimes. Of course, ang pinaka-last natin na court testimony. Konti lang yung court testimony kasi. Kahit kahit 1 hour lang ang testimony, pero uunahin natin ang Criminal Law Book 2. Pero titingnan natin bukas kung ano yung mas maganda sa inyo or mas madali. Unahin natin ang Book 1 or unahin natin ang Book 2 or court testimony. So between the two lang bukas. So ayan, mag-announce lang ako sa GC. So kung tingnan ko bukas kung maka-start ako ng 1 PM, mas maganda para mag-end tayo ng 5:30. So ganon. So kung hindi, of course, same time tayo. Okay? So thank you for joining our class today. So stop.